Have to have 4, right?
Right.
You
Here?
have to have 4 until we change it on the code.
Correct. If we're down to 5, we have to have 3.
If we change it.
Her and I were talking about 5. That's why I went.
Oh, okay.
I missed like that.
Yeah.
Me?
Oh, yeah, I know. Right here? In this paragraph? Well, I need to give it on you somewhere. Because it's Saturday. It's okay.
Hey,
No,
Jordan's
an easy
available.
one.
Oh, yeah,
That's an easy one
Jordan.
to find someone.
Thanks, Lane.
I think the.
Somebody more adult.
Did you hear him? But
We're just waiting for Cynthia to get all of our systems green here.
Looks like that's Zoom, huh?
That's true. I guess if you get it rolling, then we'll be ready when it's time to start at 5:30.
You want this or just go?
I don't know.
Jordan, that's your code, if you want to try and link for that. Or if you want me to just share the slides.
Oh, okay, so you just do it on my laptop, you're saying?
I didn't know that was possible.
I can't either. I'm.
It's 5:30, is that everything?
I think we got some business ahead of it anyway with the, I guess we don't have minutes, so I guess we are going straight to the training, aren't we? Whatever. You're good? Okay, thanks everyone for coming. We'll call the planning commission to order, whatever time it is, right at 5:30, I believe, if I'm echoing. I would entertain motion to approve the agenda.
I'll second that motion.
Got to make it first, though.
Oh, I approve, sorry. I approve the motion to approve the agenda.
Okay, you have a motion?
I second it.
Sorry.
You have a motion by Penny, second
Listening
by
to
Lane,
half.
all in favor?
Aye.
Any opposed? Motion carries. Declaration of conflict of interest, you have anything there?
No.
3, approval of minutes, none. 4, we'll turn the time over to Jordan and Sean for our land use and property rights training. Thanks for being here.
You ready to go?
Yeah, let's roll.
I had a minute.
We move quick around here.
Yeah.
I wondered if
You know what? I won't worry about the slides. I do have a handout. That's probably all we need.
we should have done these other things first.
I am. Yes. Were you gonna say?
Well,
Not
last
necessarily.
meeting.
Okay. No, you're the headliner.
You guys wouldn't have to stay here for so long.
Okay, well, I do have a handout to share, and it's just kind of a Jeopardy board to get the juices flowing, which we haven't. Print off 25, so I think there's enough for everyone to have one if they want one. Thank you. Okay. Ready to go?
Yes, sir.
I need to speak in the microphone, I guess. Is that right? To be able to.
Yeah.
Okay.
State your name, where you're from, your birthday.
Okay.
Attorney, you know what you need to do.
So yeah, my name is Jordan Cullimore. I'm an attorney with the State Property Rights Ombudsman's Office. So I find it helpful to kind of explain who we are and what we do, right? We are a publicly funded, neutral, nonpartisan agency that mediates property rights disputes, right? There's primarily 2 ways that we cover the whole state. There's 3 of us in the office. So there's me, there's Rick Plen and Marcy Jones, and then our assistant, Cynthia Nelson, which is a different Cynthia Nelson.
Oh my heck, that's funny.
And yeah, so we cover the entire state. We were created by the legislature. We've been around for 20 years, and we primarily offer two forms of dispute resolution in the areas of eminent domain and land use and development. So with eminent domain, we can do mediation at the property owner's request, right? So every time the government needs someone's property for eminent domain, they have to give the property owner that they're negotiating with a pamphlet about our office, and they can reach out, they can ask us questions, knowing that we're a neutral third party, right? And we can mediate the dispute, we can get the property owner a second appraisal if they don't think that the government's offer is reflective of fair market value, so we can help in that kind of a way. On the land use and development side, we do advisory opinions, right? So if there's a dispute between a property owner and the government about how the rules should apply to their development proposal, they can come to us, either side in that scenario. We get requests from the cities, but more often it's a property owner. We can provide a legal analysis of what a court would say in resolving the dispute. And then the third main thing we do is this, right? So we come out to local communities. It was organized by a community group, right? They said, hey, there's a lot going on down here. We'd like you to come down and talk to us about it. So the city invited me out today, Sean, right? And I'm happy to be here, right? Oh, you got up on the board. Great, thanks. So that's the handout, right? And yeah, the issue is, there's a lot of different entities that provide training, right? We focus on helping communities make good decisions insofar as they are legal decisions, right? We're attorneys, so we focus on that kind of a thing, and we want to help people know what the law is. Really, what the law tries to do, theoretically, the state law, right, is it tries to balance the public interest, what a community wants to look like, right, with property rights, private property rights. Sometimes they're one and the same, right, and they jive and they mix and things go well. Sometimes they're in conflict, though, right? And so theoretically, if everyone follows the law, then we should be striking the right balance, right, between protecting property rights while at the same time being able to pursue the public interest. But that's always the challenge, and that's what we try to help people understand is what does the law say, and what are the rules that apply to the process, right? That said, we recognize that, and I'll say we want this to be a discussion and a conversation, right? You're the chairperson, so yeah, I'll let you decide how you want it to be, but usually this is a conversation. Happy to take questions from the audience, from the planning commissioners, however you want to do it, right? But we find having a conversation is helpful and useful. And we foremost recognize that every community is different, right? Where I live in Riverton has different issues than what you guys are dealing with in Tremonton, has different issues than what they were dealing with in Monroe, right? So we like to come out and provide trainings that are responsive to what you guys are dealing with and what your needs are, right? So maybe not without picking an application and having me review it, right? Asking about questions and talking about issues that you guys are interested in, right? And so that's why we have this, if any of you knew Brent Bateman, he was my predecessor, he hired me, right? Brent is a lot more entertaining than me, but I'm a lot more intelligent than Brent. So I've said that with him in the room and he laughed, so. But yeah, Brent was very entertaining, and he kind of came up with this board, and I've inherited it and continue to take it around and have these discussions. But these are kind of some of the main issues, common legal issues that we deal with and talk with people. Again, I guess a fourth thing that we regularly do is spend time on the phone just talking with people, right? Property owners, planning commissioners, city staff, developers, city council members, the whole spectrum, right? We talk with everyone and answer questions they have. And these are a lot of the issues in trainings and on the phone and in conversations we have that come up, right? So we put these out here and say, okay, what do you want to talk about, right? I mean, I have some prepared thoughts if you want me to go through those, but typically it's kind of good to pick some things and talk through them, and that will really determine how long this training goes in many ways. So with that said, does anyone have any questions at this point, or things you want to talk about that are on the list, or otherwise, if you have something else, we want to talk about anything for sure. So
Sean, Brett, anybody? You guys have any direction you want to start with as far as a question?
I know this is exciting stuff, guys, so.
It is.
one of the directions I would like to go is the role of a planning commission and planning commissioners.
Okay, no, that's a great question and a good one to start, right? Oh, did I take that one off there? That used to be up there, the role of the planning commission. Okay. So role of the planning commission. Primarily, as I understand it and as I think about it, right, the planning commission is a technical advisory body in many ways. Primarily, and by statute, state statute, that's their first and foremost role, right? Is to be kind of a technical advisory committee to the city council in making land use decisions, right? Anytime, and when I say land use decisions, I mean legislative decisions, right? So that's another big one up there, legislative and administrative decisions, right? When we're talking about legislative decisions, we're talking about making the rules that apply, right? So state law, it kind of sets the bounds and it's specific about a few things, but in most regards, it gives a lot of discretion and a lot of authority to the local communities, to you guys, right, to the city, to decide what you want the rules to be, right? And we're talking about land use specifically. So we're talking about your general plan, that's a legislative decision. Your zoning ordinance, your zone map, right? Those are kind of the three main areas where you're making legislative decisions. You're making recommendations to the city council, because they're ultimately the ones that make the rules, right? They're the legislative body of the city. They're the rule makers, but the state has said, hey, with land use, there's a lot that goes into that, right? And because of that, they say every city, if you want to plan, right, if you want to have zoning ordinances, if you want to regulate people's land, then you also have to have a planning commission that considers, what rules should be in place, what types of zones you want to create, where you want to put those zones, residential, commercial, industrial, agricultural, right? Mixed use, recreational, right? There's all sorts of different types of zoning you can do. And your guys' job is to kind of, number one, work on the general plan, right? Make recommendations there so that you have a vision for the community of what you want your community to look like. And also get ahead of things, right? So that growth happens orderly, right? Maybe that's another thing to briefly touch on, right? Growth is touching communities that it hasn't touched in the past, right? We're all starting to experience it. But yeah, having a general plan, ideally and theoretically, right, will help you to say, okay, here's where we envision the city growing. These are the types of facilities and this is the type of infrastructure we'll need to serve that, the development. Different cities do it different ways. Some just say, hey, this is what we want it to look like. Others try to kind of, look at market data, right, and decide, okay, what is the market going to do? And how can we anticipate that? And how can we help to facilitate that, right, and provide services, But yeah, that's all the work of the Planning Commission, right, is considering those things, working with your staff to the extent that you have staff that works on this kind of thing, coming up with a general plan, and then once you have a plan in place, saying, okay, we have a vision, the zoning ordinance implements that vision, right? And that's the actual, because the general plan is just advisory, unless your local ordinance makes it mandatory, right? But by state law, it only has to be advisory, and then you enact zoning ordinances, right? You create a zone map. You say, okay, this is to try to create an orderly community that everyone's going to be proud of, right? And hopefully that also respects property rights, right? That's the balance you have to strike. Allowing people to do things with their land that the market supports and that is useful, right? But at the same time, keeping things reasonable so that as one Supreme Court case said, the pig isn't in the parlor, right? So that's the idea behind it, and that's primarily the biggest role, I'd say, of the Planning Commission, right? Now, when we talk about administrative decisions, we're talking about subdivision applications, site plan applications, building permits is an administrative application, right? Oh, annexation is another one in the legislative box, right? But yeah, so the applications where people are coming in and saying, okay, here's my proposal, determine, and you're determining whether or not it complies with the rules that are in place, right? That's an administrative decision. And, you know, state law doesn't say the planning commission has to make those decisions, right? You can delegate to a land use authority, so you can designate yourselves as the land use authority. Well, excuse me, the city council does all this, right? So the city council can designate themselves as the land use authority. They can delegate it to you as a planning commission. They can also say, staff, we're gonna have you be the land use authority, right? And because the idea being that in most cases with an administrative decision, you're not making the law at that point. And when you're making the law, you can have policy discussions, right? You can say, what are our preferences? What do we want to see here? What do we like, you know? With an administrative decision, that discussion is over, frankly, right? And the pendulum kind of swings toward predictability for the applicant and the property owner so that they can say, bring in their application and know what the rules that apply to their application are going to be, right? So when someone comes in, brings in their administrative application and pays the fee, that locks in the rules, right? We talk about vesting, not sure, yeah, vested rights, right? They vest in the rules that apply, and at that point, it's just a conversation about, okay, what are the development standards? What's the zoning ordinance say? What's the minimum lot size? All those types of things, and you're reviewing the application for compliance, and if it complies, it's entitled to approval, right? So in a lot of communities, and I'm guessing in this one, you guys are the land use authority for some things, right? You gotta keep in mind which hat you're wearing, right? As Brent would always say. Are you wearing the legislative hat or are you wearing the administrative hat? If you're wearing the legislative hat, yeah, get input from the public about what their preferences are and their what they want their community to look like. Think about what's going to be best for your community, where facilities are going to be best located, right? And come up with ordinances that are going to reflect that, right? And propose those to the city council. With administrative decisions, you take off your legislative policymaker hat and you put on your administrator hat, right? And you say, okay, our ordinances should address all of that preference stuff that we talked about before, right? And so now we're just looking to make sure the application complies. So, you know, while that's not in state statute as one of your primary roles, it is nonetheless a role that you have in cities, right? And you need to keep that in mind with administrative decisions, that you've taken off the policymaker hat and you've put on the administrator hat. And if everything complies with the rules, you approve it. If it doesn't comply, you don't approve it, right? That's the flip side. But that becomes the conversation. So that was a long-winded answer to your question, but that's you know, how I view largely the primary roles of the planning commission, if that makes sense.
So in some of with your experience that you had with all these planning commissions, draw that parallel between the general plan and the planning commission. Do they usually help develop that plan, the general plan, and like you said, then they help follow that? I mean, how do those fit together, the planning commission and the general plan?
Okay, yeah, so the general plan, in a lot of ways, that's your baby. That's the planning commission's baby, right? Yeah, when you have a general plan, it starts with the planning commission and it starts with a public hearing with the planning commission, right? Where you're getting input from the community, and different communities engage the public in different ways, right? For a time back in the day, I worked as a city planner in Linden City, right? And during Linden days, we put out a booth, right? And we said, hey, everyone, you know, we're working on the general plan. Come and tell us your ideas. And we had surveys, right? And now we have social media, and that can get all sorts of exciting, right? But you can pull a lot from these sources, right? And the idea is hopefully that you're getting information from your community about what they want their community to look like, right? In addition, though, since you're a technical advisory committee, right, you're also turning to experts, right? Planners, if you have them, right? Engineers, maybe, you know, realtors for market data or something like that, to try to find out, okay, you know, what is going to be best and where, you know, because not every area of town is going to support every type of use, frankly, right? And so part of your role is to figure that out, right? And then hopefully your general plan strikes that balance of saying, okay, we want a community, and this is where things should generally go, right? But yeah, the planning commission should be very intimately involved in coming up with a general plan and proposing that plan to the city council. They make the ultimate decision, right? And they can change your recommendations. They don't have to follow it, right? But they have to consider it. They have to look at your recommendation. And yeah, your general plan is where you're making a lot of those decisions. And communities should take them seriously, right? Even though they're advisory document, there's requirements to keep them updated for a reason. And hopefully they're good planning documents so that you can have orderly growth to the extent that you're experiencing growth in your communities, right?
Did we ever find a general plan? Did we ever?
Somewhat of a general plan, but we're working on one right now, but we need to be more involved.
For sure.
Yeah, and I mean, some communities have general plans that are big binders, right? Others might be a few pages. The recommendation is have a general plan that you're going to use.
Right?
If you go through, if you hire consultants and you make a big old binder that's full of a lot of boilerplate from their prior experience, right? Those typically just go and sit on the shelf and no one knows what they say, right? But if you have a document that's readable in one sitting and has some general, that's the idea behind a general plan. Again, it's supposed to be general, right? Your ordinances, that's where you get into the details, and you guys are involved in that as well, right? But that's where there's more detail. Again, this is all theoretically. Hopefully you can strike the balance, you know what I mean?
So ordinance and policy development is a role of the planning commission.
Sure, yep, definitely. Yep, I'd say that is your primary role, both through the general plan and through recommending land use ordinances. Yep, for sure. Good questions.
My questions.
Perfect. Any others you guys have pop through your brains?
Not right now, maybe in a minute.
I had one quick one talking about vesting.
Yeah, you
So
bet.
somebody applies for a subdivision or a site plan application. I mean, I know the rule, what rules aren't vested? Does that make sense?
Yes, it does make sense.
Because I think they're not all vested, but some of them are and some of them aren't. But I'm a little fuzzy on which ones are and which ones aren't.
Okay, that is a question that not infrequently comes up in an advisory opinion request, right? Because a property owner or a developer will say, hey, we think these are the rules that apply. And the city may say, no, only these apply, right? And there's language in state law that basically says, the way I read it, right, is that you vest in the rules that apply to what the application is proposing, essentially, right? So if the application is asking for approval of a subdivision, then all the rules that apply to a subdivision apply, right? Now,
Talking like roads, everything.
yep, your street standards, all the standards for putting in.
City standards or state standards?
Both.
Okay.
Both. Yep, that's a good question. So yeah, all the rules, state and local, right?
Okay.
That deal with what they're proposing, that deal with the application. Ideally, right? You might have, you could have lists in your ordinance, right? That say, okay, concept plan approval, right? These are the items we're looking at, right? And then you know that, okay, whatever rules apply to those types of things are the ones that vest, right? Preliminary plat application, final plat application, right? These are the things that are being reviewed, A lot of cities will have checklists that outline all that, but they're not necessarily in the ordinance, right? If you put it in the ordinance, then that can help to kind of flesh out, okay, if a rule applies to this, then it's vested, you know what I mean? But really, yeah, so typically I would say if someone comes in and applies for a subdivision, right? And then you're going through the process of preliminary and final plat, right? They're vested in all the rules that apply to subdivision in that process of getting a preliminary and a final plat, right? Similar with a site plan, right? If they're bringing a site plan application, then all the rules vest that are going to apply to that site plan application. So I'd say most of the time, once an application comes in and they pay the fee, the city they've lost the opportunity to change the rules on whatever rules apply to that application, to be honest, right?
1 year.
Well, until the application is approved. If the application, when you say 1 year, is there something in your ordinance that says that if it's not, what do
I
you
always
mean?
thought it was a year, but
Okay.
I guess maybe it's just in my brain. I'm not sure. I just assumed you had like, you make the application, you have a year to get it approved or not, and then it reverts back.
Theoretically, I mean, there's nothing specifically that addresses that in state law. I have seen local ordinances that say if you don't move forward on the application or you don't make progress on an application for a year, then you have to come back in and reapply and you revest, right? But the idea is that as long as they make application, and state law, if they make application and then they're diligently pursuing approval, it could take a few years, right? But they're still vested in whatever the rules were when they first applied, as long as they're continuing to make progress and moving forward. Does that make sense?
Is that kind of what ours says, Steve?
Usually it's when there's inactivity, right? And the ones that I've seen that timeline of the year starts
The tick.
to tick. And then, yeah, if they don't, if they come back in a year and 10 days, right, and say, we're ready to move forward, then there's a possibility that the city may be able to say, oh, you need to resubmit, right? And we revest in whatever the law, maybe the laws are all the same, right? Maybe nothing's changed in a year, but if something has, then yeah, they would need to consider that for sure. So yeah, good question.
Other questions?
Mr. Chair, I was just gonna
Please.
add, so one of the things that we do, Jordan, in our land use ordinance, we also talk about vested rights after they go through an application. So like concept plan, there is no vested rights.
Okay.
Because there's no entitlement for them to proceed in any
Yeah.
direction. But for example, preliminary plat, they get a vesting if they get approval of the preliminary plat. Then it also talks about them being vested to move forward to the final plat with, the density, the lot configuration, road configurations, it's general plan.
Yeah.
And then like a vesting for final plat is that they're eligible to record the subdivision plat
Okay.
in, at the county recorder's office.
Mm-hmm.
So we have that as well. in our
Yeah.
ordinance.
Yeah, no, that all sounds, here's one thing I will say, right? If you have an ordinance that talks about the concept plan phase of things, and it's clear that nothing vests, you'll probably get very few people bringing in concept plans if the city uses that as an opportunity to try to quickly change the rules before they bring preliminary plat in, right? And I don't know if that's applicable to what you're saying or not, right? But yeah, it's important to recognize some of these things, right? Because really, in my experience with land use applications and land use decisions, you want there to be an open conversation, right, between the person proposing the development and the city, right? Because if there's not, then you usually get bad development. If everyone's keeping secrets, right, and just falling back on their legal positions, right, then usually the product that comes out doesn't look that great, right? So just be careful about those things when you talk about, hey, tell us what you want to do, and then you use that as an opportunity to change your rules, you know what I mean? And that's part of the reason vested rights exist, frankly, right, is to prevent communities from getting a preview and deciding if they like it, and then, saying no if they don't, essentially, right? Put your rules in place, say what you want, and then when people come in and want to do that, let them do it, kind of a thing is the idea, right? But yeah, so as far as vesting goes, really that's kind of the baseline, right, is you vest in whatever the application is proposing, essentially. And if you do that, then you'll be in a safe place with striking that balance, right, between community interest and private property rights.
Right, but is it possible for the city by ordinance to specifically define that they won't allow vesting upon a concept application?
Again, like I say, you can do that, but I think you run into legal problems if you then also start saying the concept plan is also required, right? Yeah,
That's what I was gonna say.
yeah.
Oh,
if
it
it's-
isn't.
Yeah, and if it were to be required and you said there is no vesting, I'd say state law is gonna supersede that, right? And say, nope, sorry. That goes in the face of the entire idea of vesting, right? The whole idea behind vested rights is to give people predictability and certainty about what rules are going to apply to them. And if you have a process that says you have to tell us what you're going to do before we let you vest, then that goes against, what the courts have said and what state law says about how vesting applies, if that makes sense.
Yes.
So yeah, so you can definitely have a concept stage that's not required, right? And that says, okay, there's nothing that vests here, and that's fine, right? Again, if I've seen that work very well in a lot of communities, right? To the extent that the community doesn't use that as an opportunity to then change the rules real quick before an application. The first time you do that, your concept plan applications are gonna drop significantly, right? People aren't gonna want to tell you what they're doing before they bring in the application that will vest, you know what I mean? So yeah, if you can build that trust, right, and say, hey, yep, we have this concept plan stage, we want you to come in so we can have a conversation, and again, you use that responsibly, right? Then it can be a great part of the process and it can really facilitate the conversation. But there are a few pitfalls if you try to use it in the face of the vesting rules. Does that make sense?
Perfect. Any other questions you guys have? Do you want him to do his presentation?
But we've covered pretty much all of it.
I want to turn over the card, public input versus clamor.
Okay.
What were you going to talk about on that?
Yeah, that's a great question. So, and we kind of already touched on it, right? When we're making a legislative decision, right, and we're deciding what preferences we want and what we want the policy to be, it's typically referred to as public input, right? You're getting information from the public, in addition to maybe some evidence about what the situation is, and preferences, right? So at the legislative stage, the public's opinion is essential to the process. You want to listen to that, you want to consider it, right? If it's an administrative decision, right, that's when the courts have come up with this term of public clamor, right? Where an application for a gas station comes in, right, in a commercial zone that's right next to a residential maybe, It's an approved use in that zone. They meet all the requirements, they've submitted their application, they've paid their fee, and the public turns out, right, and they say, wait a second, we don't want this, right? Again, if it were at the legislative stage where you're putting the zones in place and someone in advance said, ooh, we don't want gas stations by those houses, let's not do commercial here, right? Yeah, consider that and decide whether or not you want to put a commercial zone here next to a residential zone. But if you've already done that and the application comes in and now you're considering that application and the public comes out and says, we don't want that here, at that point it's public clamor and you don't get to listen to it, right? You don't get to consider it. Because at that point, again, you're taking the rules and you're applying them to the application. And if they're in a commercial zone and they meet all the setback requirements and they meet all the requirements from all the different departments that regulate gas stations, right? Then they're entitled to approval and the public's preference is no longer part of the equation at that stage, if that makes sense. So yeah.
So what about it like an annexation?
So an annexation, right, that's a legislative decision.
Okay.
Yep. And annexations are interesting because there are,
So then public input is,
yeah, you can ask, right? I mean,
listen.
the public, do we want to annex this unincorporated area into our community? Yeah, I mean, if the community says, nah, we don't want to grow that direction, or, we think that wouldn't be good for X, Y, and Z reasons, yeah, you can listen to that, right? There is a situation where, I'll just throw this out here, right? And I don't know if this will come up in your community or not, but annexation is kind of interesting because, there's also like technical requirements that have to be met, right? So if you meet all the technical requirements and the community thinks it's in the public interest, then you can accept it, right? There is this situation where some of the property owners in the annexation area can kick it to what's called a boundary commission. And the boundary commission, then, I can't remember off the top of my head who it's composed of, but it's composed of different, entities and individuals, and they'll just look at it from a technical standpoint and say, doesn't make sense to annex this in, right? And then if they make a recommendation back that it should be annexed, usually the city council is going to have to follow that recommendation, right? So there's a process that's followed, but assuming that doesn't happen, right? Assuming it isn't kicked to the boundary commission, then yeah, it's the city council that's making a decision of whether or not it's in the public interest to annex this into our community, right? For sure.
I
So yeah,
like
you can consider public
I
input,
like what
sorry.
you mentioned about, that public input can be researched with this group. It doesn't have to wait till it's city council, but we really ought to be researching that out as part of our research in this group.
Yeah, ideally, there's no surprises when it goes to the city council, right? You've vetted all that, you've given everyone their due process, everyone's, now, I guess if you make a decision that a lot of people don't like, they're still gonna come out, right? And they're still gonna talk, but that's the beauty of America, right? And democracy is everyone gets a say, so.
Exactly.
Not everyone's say is implemented, right? But everyone gets to speak their mind, so.
Please.
Could you talk, we talk a lot about exactions through the development process and
Yeah.
sort of the tests associated with exactions.
Okay.
So, but it'd be great if you could explain that.
Yeah, you bet.
One, too.
So exactions, that is the number one topic, right, that we do advisory opinions on. And in many ways, it's largely because, there's a clearly legal exaction and there's a clearly illegal exaction. And then there's this really big gray area, right? Where, and so that's where a lot of disputes arises when people get in that gray area and they'll come to our office. But an exaction, so anytime you do a subdivision, right, or any sort of a development approval, there's inevitably going to be services that need to be provided, right? We're talking about transportation, water, sewer, electrical, those types of things, right? All the services that cities typically provide to people that give us our standard of living, right? An exaction is something that the developer builds and then gives to the city, right? So in the end, the city owns it and maintains it. And it provides a service. So we're talking about roads, we're talking about sewer lines, we're talking about water lines, landscaping in the right of way, those types of things, right? All those are exactions. And what the courts have said is proper exactions are when you require the developer to construct and pay for public improvements, we call them, right? That offset their impact, right? But no one else's. Because when they start offsetting someone else's impact, then it becomes an illegal exaction and it's a taking of private property without compensation under the Constitution, right? So, if we're talking about like a 50-lot subdivision, internal roads to that subdivision, everyone agrees that those are all lawful exactions, right? Because that subdivision is going to need those roads to provide access to those houses. But, the further away you get from that, right, if you're having them also build, this collector or arterial road and that extends further outside the subdivision, right? That starts offsetting other people's impacts, right? That need transportation services, and that's when you get the state law talks about system improvements and project improvements, right? And everyone seems to agree that project improvements, those are lawful exactions. You can require a developer to build those and turn them over to the city, right? System improvements, those are ones that you can't have any one developer construct, right, or build of their own accord, right? Because those serve more people, right? Not just that developer. And that's what like impact fees are for, right? You collect impact fees to build system improvements, And you might be able to have one developer construct some portion of a system improvement, right? But usually there's also some negotiation to say, okay, and you find that happy medium of where the developer and the city agree about what the developer needs and what the city can require, right? And if you have that kind of a process, usually you always get the right result, right? But inevitably, even when both sides are acting in good faith, sometimes disputes arise, right? And again, that's why it's the number one topic that we look at, because sometimes cities and developers just need a third party to look at it and say, hey, is this lawful or not? But that's the standard, right? You can require a property owner or developer to offset their own impacts and no one else's. And if you do that, you're staying within that realm of lawful exactions and you're not getting into illegal exactions that are violating the takings clause of the Constitution. So does that answer the question?
Yeah,
Okay.
and can you parlay that into impact fees and you touched upon impact fees and how they're essentially the exaction and the proportionality?
So impact fees, and there's an impact fee act, right, in the state, and those are a lot more regulated in more detail, right? But impact fees, you're charging for system improvements. So ideally, well, you have to, right? If you're gonna charge impact fees, you have to have a capital facilities plan, right? These system improvements that your water tanks, collector roads, arterial roads, right? Trunk lines for your sewer and your water lines, right? Those improvements that are serving the larger community. Some of them are probably gonna go through individual developments, right? Ideally, instead of making those developers build those facilities, you're collecting impact fees, right? And the whole process of the Impact Fee Act in creating a facilities plan and then doing this analysis that's required by state law that we won't bore anyone with tonight, right? Is that you're trying to determine each individual developer's contribution and fair share to that system improvement, right? And so ideally, if you go through this process and produce an impact fee, then you're charging a fee that says, okay, yeah, we can't make you build this whole facility, but each property, right, each development does have some contribution to this system improvement. And so we're capturing that in an impact fee, right? And so that's how you account for those system improvements. And one way, right, to pay for system improvements is through charging impact fees.
I have a quick question on timelines in relation to those exactions. Let's say the city exacts secondary water or fee in lieu for curb and gutter or something of that nature. Are there time limits that they have to provide that service or install that curb and gutter or anything like that for those exactions?
Yes, so as far as an exaction goes, if we're just talking about improvements in a subdivision, you can only exact it if you need it now, is the short answer, right? You can't and because otherwise you're offsetting someone else's impact, right? If you say we need this, but we don't need it now, then it's not their impact you're offsetting. It's someone else's in the future impact, right?
It's like secondary water and the system won't be built out for 7 years, say. Can they exact the water under that design or no?
Yeah, I mean, if you have a plan, that gives you maybe a little more coverage to say, we need it, but we also need to kind of bring it together. Maybe some guidance, right, is with impact fees, if you don't spend or encumber those within 6 years, you have to give it back to the developer, right? And so that's kind of maybe a good yardstick to decide, okay, are we going to build this within, so the state has said with impact fees specifically, 6 years is a reasonable timeline within which you should be getting those services you said you need to provide in place, right? And so it doesn't say that specifically with exactions, but it's maybe a good yardstick to consider for sure, right?
What about fee in lieu? Is it treated differently at all?
Fee in lieu, you got to be careful with those, and it's similar, I'd say, right? So are we talking about a fee in lieu and
Like curb gutter
Yeah,
and sidewalk as an example.
Yeah. I'm familiar with that kind of a regime, right? Where you're looking at it and saying, okay, it doesn't make sense for this one property, correct me if I'm wrong, but this is the scenario I'm familiar with, right? So you have like a road and it's all just soft shoulder and the drainage is dealt with by like a bar ditch or something, right? And then someone comes along and develops and the standard says you need sidewalk here, but it doesn't make sense to put sidewalk there because that's going to mess up the whole drainage plan, right?
Right.
And so you say, pay a fee in lieu and we'll keep that in this, fund, right? And then when we're ready to build it all, we'll take that fund and we'll build it, right? No one's ever contested that practice in court. I think largely because by the time you're going to build that sidewalk, they got a screaming deal on what they paid for it, right? So you don't have people coming back and saying we were wronged, right, and charged too much because that's just from a practical standpoint. You know what I mean? So we don't have any case law on it, whether or not that's unlawful, right? But what the law does says is, you should charge for people's impact at the time that they're developing. You know what I mean? So if you can look at a fee in lieu, my sense is that if you're following those principles, you're probably going to be fine, right? But at the same time, there's a really good possibility that if someone comes back to you in 5 or 10 years and says, you still haven't built this sidewalk, you need to give me my money back, right? You should really consider whether or not you might need to, right? So,
Okay,
because you haven't used it for that, you know, so.
sure. Questions that have come up? Steve, you have any questions? I had a question, and maybe this is not the time, Sean, maybe correct me, but I feel like I have no clue what's this whole referendum and how all that is playing out. If that is something we should or could talk about here, I would appreciate it. So what if we have an annexation, it's approved by the city council, and then a referendum like the one in Providence is the one I'm familiar with.
Okay.
How does that work, and how does that play out, and where does it go?
Yeah, no, that's a great question. And the best answer I can give there is with a referendum, right? So the whole idea behind a referendum is when the city council makes a decision, there might be someone in the community that says, city council, you got it wrong, right? You made the wrong legislative decision. And the courts have said that the people's power, right? The power of the community is co-equal, right, to the city council's authority in making the law, right? And annexation is a legislative decision, right? So yeah, if you follow all the requirements, someone can submit a petition, right, to put it on the ballot and say, you know what, we think the city council didn't make the right decision here, that the community would agree with, and so you put it onto the ballot and you let the people decide, right? As far as the process goes, all I can tell you, it's super technical, frankly, right? And it reads like a checklist in state law. And so really, you just have to go through, and the city needs to make sure they're following all those steps, right? And they need to review it and make sure it complies and it's eligible as a legislative decision. And then they need to produce all the signature books, right? And then the petitioners have a certain amount of time to go get all the signatures, right? They have to get a certain number of signatures, a certain percentage of voters from the last election, right? To say that, yeah, this is a significant enough issue that it needs to go on the ballot, right? You get all those books back, again, the city has to go through and make sure all the signatures are right, follow the procedures, follow the rules. And then if it does, right, if it meets all those requirements, it goes on to the next ballot, and the people decide whether or not to confirm the city council's decision or invalidate it, right?
So what happens if they invalidate it?
If they invalidate it, then it goes back to whatever it was before the city council made the decision. And sometimes, and the interesting thing about that, and the kicker, right, is there's nothing in state law that says the city council can't then the next day go back and make the same decision, right? So sometimes it becomes this battle between the community and the city council, right? And that's why you want to maintain that relationship, frankly, right? And usually kind of the biggest referendum is the next election, right? If all those city council's members get voted off, then they probably weren't making decisions that were in the public's interest, right? So,
But so what if previously it was in the county and it was unzoned?
then it goes back to being in the county and unzoned.
Well,
If the referendum succeeds, or am I missing something?
just, these are nuanced questions, and.
Yeah, I'm answering them very generally, admittedly.
So the annexation was one ordinance that was approved.
Oh,
The zoning and development agreement was another ordinance separate, and that's what the referendum is about.
for the second one.
Yes,
Okay. So the annexation isn't being referred.
right. It's
Okay.
approved and already.
But so what happens then, though, if it's then put back? What does it go back to if it was unzoned prior to being annexed?
Well,
Well, we
we
zoned it.
gave there's a fiscal and a legal analysis that sort of described that. And, in the position, the city's legal analysis, and I'll let maybe Dustin, you want to say what it is, Dustin?
Just simply that there's code sections that talk about that if property is brought into the city without zoning, then it's to use, and it's not zones, it's to use uses that are similar to the land around it. And then also there's another section that says that the developer gets, I'm paraphrasing here, gets the benefit of the doubt of what those are. And so specifically as it relates to what was recently happening here in Tremont City, there are several uses surrounding. There are apartment uses, there are residential uses, there are commercial uses. So each one of those uses comes into play with the developer getting the benefit of the doubt of those uses.
Yep. Yeah, and that's all in state law, right? So if you have an area in the city that's unzoned, like he said, right, the state law says that if someone brings in a proposal, then they get to be approved if their use is similar to surrounding uses, right? And that's pretty subjective, frankly. But there's also that provision that says you interpret any ambiguity in favor of the property owner's desired use. So if there's a reasonable argument to be made that their proposal is compatible with surrounding uses, then from a legal standpoint, you're probably going to need to approve them.
Thank you. I had another question, and maybe you guys are all thinking it, but I'll say it, I'm not afraid. What if generally the public is always against everything? And it's not possible to not approve everything. You know, like how as a planning commission, how do you articulate that? I mean, of course, we have to take it all into account, but I mean, essentially, if we listen to all the public, all we'd build is multi-million-dollar houses, and that's all we'd have in the whole
1
city.
acre lots,
Yeah.
1 acre lots.
You know, but I just feel like it's kind of like our housing situation is emergency situation. So it's like, how do you articulate that?
If I had an answer to that question, I'd be a lot richer, frankly, right? I'd be rich, number one, I guess I should say. But it's a great question, and there's no right answer, frankly, right? I mean, that's what all the communities are dealing with right now, right? And it's hard, right? And it comes back to, balancing the public interest with private property rights, you know what I mean? And then also that bigger picture, like you say, of addressing maybe more systemic issues, right? About housing affordability or something like that, right? I mean, a lot of it is just the work of communities, right? To try to talk through these issues and educate and, I'm not even going to say who's right or wrong necessarily, right? But all the issues are real issues and all the issues need to be engaged with, right? And what the best way to address those issues is, I mean, you as a community, you really just got to care about it and address it and try to do what you consider to be. I don't like to always use the word right or wrong in these scenarios, right? But sometimes there is a right thing, sometimes there isn't a right thing to do, right? It really just depends. I'm getting super philosophical, right? It depends on what your values are, right? And what you want to pursue in your communities. And it's you're asking questions above the lawyer's pay grade, right? So, but it is a real issue, and hopefully, and ideally, everyone's coming to the table civilly, and they're discussing the issues, and they're looking at the facts, and they're looking at the realities, and they're making hard decisions, right? That's all that I'll say about that.
Thank you. Is it possible to not allow specific zones in a city? Like say we don't want to have that particular zone, that particular use.
In most cases, yes, right? There are certain uses, sexually oriented businesses, right? Courts have said that's a form of free speech, right? So you have to allow it somewhere, right? But if we're talking about like industrial zones or something like that, or a certain type of industrial use, yeah, as long as you're being reasonable about things, you don't have to include everything everywhere by any means. And frankly, there are some communities that are bedroom communities, and there really isn't an area where industrial or manufacturing makes sense or something like that. If you're talking about those general uses and you're making reasonable decisions, then there's nothing that says you can't exclude those, if that makes sense, right?
Jordan, can you touch upon, I mean, as a planning commission, there's 3 things that you need to include in the general plan, which is transportation, land use, and affordable housing. Say that, and as it relates to affordable housing, then there's certain strategies that the city's required to essentially choose from in the state code. So
Yeah, that's a good point.
One of the hot topics in Tremont is affordable housing, density, how we accomplish those state mandated items that frankly are changing probably as we speak, or in the process of changing through this legislative session that is currently in session. So there's those types of boundaries that come into play and requirements that cities have to apply.
Yeah, you bet. And that's a good point. And so if we're talking about housing affordability specifically, right? Yeah. I mean, the standard always is that the state, right, they delegate their authority to local governments, right? Local governments, cities are creatures of the state, right? And so all of your authority to zone and to regulate comes from the state. And kind of the baseline is the state says local governments, you know, zoning is a local concern, so you guys make decisions. But the reality is if the state, right, the state legislature specifically, deems that the cities aren't making the right decisions about things, then they start taking some of that authority away, right? And so, yeah, you're starting to see that, frankly, right? Like the state legislature very, iteratively is starting to say, hey, housing affordability is a problem, right? And so the first step they've taken is to say, you need to put it in your general plans and you need to be thinking about it, right? And you need to have strategies in place to accommodate it, right? And the reality is if cities are making decisions that the state feels aren't the right decisions, right, then they'll continue to whittle away at that local authority. And there might be situations where, I mean, you've seen around the country, right, where single-family zoning has been abolished, right? And I don't know if and when that will ever happen in Utah, right? But it's the state legislature ultimately that will make those decisions, right? So. And so, yeah, if you're following all the rules, if you're trying to be reasonable, if you're having the tough conversations and trying to do your part, then the state legislature should leave that authority with communities to kind of determine their own path, right? But it's the joy of governing sometimes, right? So.
But there's not like a number that they've put out that we have to supply of affordable housing or a percentage.
To this point, not that I'm aware of, right? Again, it's just, right now, there's like Sean said,
have
the
to do.
menu of options, and you have to be pursuing some of those options, right?
Well,
Yeah.
I think, and maybe I think this requires you to do a 5-year projection, so every year, the city is required to report annually by December 1st, and, you know, they help provide data, which I think they're working on the process of refining the data that they provide us, but we're required to essentially project out affordable housing in 5-year increments at different levels of affordability. You know, and they call that the annual or average median income. It's the county's
AMI.
annual AMI. And they're at 80% thresholds, 50%, 30% thresholds. So they are, it is pretty specific on what we need to do, and you know, they withhold funds if you don't report. You know, they have different levers to encourage cities, you know, to comply, and, you know, to meet their, you know, what they've determined are, you know, reasonable levels of providing affordable housing.
Yeah, I'm not the policymaker, but the long of the short of it is we do need to find some places that our kids can live in, right? So, anyway.
You have any other questions as a Brett, Steve, Sean, audience, council members? Do you guys have any other questions while we have it open?
Thanks for having me.
Thank you, Jordan.
Oh, yeah, and so here's my information, right? Anyone, you know, there's our phone number, that's my email address, and our website. If you have any questions or want to talk offline or otherwise, give me a call or send me an email, and love to talk with you about it. So, thanks for having me.
Thanks for coming.
Thank you. Yes.
I was just gonna say, so, for the next couple of meetings, you know, with the council or commission's consent, we wanted to continue providing some training. The state code requires a certain amount of training that occurs annually.
Great.
And we felt like between Dustin, myself, and maybe we'll look for others who, you know, who we can include, like, you know, Jordan or certainly tonight, but other ones. If that's okay, we'll kind of coordinate with you then going forward to provide those hours.
Yeah, do you guys feel good about that? I mean, I feel like more information is better than less. Thank you, Jordan. Yeah, I think that'd be great, Sean, Dustin, for sure.
It's 4 hours a year. Yeah, the state code talks about specifically different topics. And so what I would probably do is slip out and talk to Dustin, and we can come up with some of the topics that he might want to present on, and maybe figure out other presenters.
Great.
Unless you have any specific topics you want to dive deeper into.
You guys have anything specific?
Not off the top of my head. I'll be thinking.
One of the topics, interesting enough,
Yeah, you go to 6 or 10, you mean?
4 hours is good.
Well, maybe a good place to start, like Brett mentioned, would be to start with the general plan.
For sure.
As far as,
Definitely,
What's
because we're kind
happening
of just a
with that?
hodgepodge now.
rules and
I mean, yeah, I don't think that's a bad idea, for sure.
just.
Well, maybe reviewing what we have and reviewing what's
We
the
wanna go.
proposal.
Yeah.
And then we can at least be mulling and having a vision of where we're going to be able to help be ready. So it's not just to show up one meeting and we have to approve it. You know what I mean? So that'd be great.
I'll check in on the status. The consultant has making some changes to the plan, and at that point, I think there's a good enough version to present to the commission to start the discussion.
Great.
So there is a version of the general plan in the works. Oh,
Oh, very
cool.
much so, yeah. It's like, it includes land use. It's an integrated land use plan that includes some of the transportation issues that we recently adopted, and trying to, marry it with land use. And it also includes parks and recreation. It's about 100 pages of
Light reading.
Yeah. Simple, simplified,
Good.
Like pictures?
as long as they're colored. We're good.
Good. Thanks, Sean. We will open the public hearing to receive public input on a proposed zoning map amendment on 1 acre parcel of property located 2495 West, 1000 North. Proposed rezone would be from current R120 half acre zoning to R110 quarter acre zoning. I think I do have a comment that was mailed in. I guess I'll start with that, if that's okay, Steve, just so we get it out of the way so I don't forget. This is from April Wheatley, 2576 West, 1000 North in Tremonton. I am writing to urge you not to grant Mr. Pina's request to rezone the property located 2495 West, 1000 North into the R120 quarter acre zoning. I do not begrudge Mr. Pina's ability to sell his land as it is currently zoned as R120 half acre residential. However, his proposal to stack 3 building lots running north to south on his property would increase congestion and fundamentally change the intersection that is just to the north of the property. I live just west of Mr. Pina's property. My children catch the school bus at the intersection of 1000 North and Mountain Road, the entrance of the Spring Acres subdivision. I presume that a roadway would need to be added to this intersection to accommodate the additional 3 building lots that are proposed. An additional right-of-way coming onto 1000 North from the south is problematic in this area for several reasons. 1000 North currently narrows just after you travel west past the intersection of 2300 West. That is just several hundred yards east of the property in question. If you have ever tried to turn west onto 1000 North from the intersection on 2300 West, then you know that it is almost a blind corner coming up on that road into oncoming traffic. Visibility is not good with the slope of the land and the rose bushes that are currently planted on the corner of the property at the 2300 West and 1000 North intersection. Visibility coming out of a roadway access at 2495 West, 1000 North property would be even more of a concern because of the slope of the site and the additional narrowness of 1000 North at that point. The home just west of the proposed lots is situated at an angle, and drivers turning onto 1000 North from the new proposed lots would be at a serious disadvantage to see oncoming traffic. I seriously worry about the safety of the intersection at 1000 North and Mountain Road if these 3 additional lots are rezoned and then sold as Mr. Pina intends. I don't believe a single lot driveway would be as dangerous. There would be less traffic coming and going from a single driveway, and it could be situated with access to 1000 North so as not to endanger oncoming traffic and the departing party. Please take this into consideration. I mean no ill will to Mr. Pina. I appreciate the service that he has rendered our country through his military career, and I see why he would like to capitalize on the land he owns by selling it in 3 lots instead of 1. However, for the reasons stated above, I don't believe it is in the best interest of Tremont City or the surrounding communities to rezone this lot. Sincerely, April Wheatley. And now we will open the public hearing to hear from any others that would like to speak. Come up to the microphone. You got 3 minutes. Come up if she's gonna.
Want me to time it, Micah?
What?
Want me to time it again?
Okay.
Sorry, never done this before.
It's okay. It's not that formal. They just have to get it on the recording, so let us know who you are.
Micah Nance. I'm 2421 West, 1000 North. We are the property that's just west of, or is it east? Oh, it's just east, sorry. The corner property where the rose bushes are. The utilities would have to run through our property. He had an easement 2 years ago and did not use that. I feel that having more homes there would just cause problems. I think it should just stay as what it's zoned. We don't have any ill feelings towards him at all, but development of that property, that would just, we bought the property to not have neighbors and to live in Tremont and with it open and it's just, we're against it. I'm sorry.
Is that easement no longer valid? Is
It's
that
no
what you're
longer
saying?
valid.
Okay.
Thank you.
Thanks.
Nance, I believe.
Hello, I'm
How are you?
Leslie Gibbs, and we live on the west side of this property. We've been there for over 40 years. We'll be happy to have him as a neighbor, but when he bought the property, he knew what it was zoned at the time. It's horse property, agriculture property. We have 4 acres there that is pasture, that we have, we also have a well that will support, right now we only have a horse in it, but we do have a well that would support, if we wanted to put sheep, we could. If we wanted to, a few sheep, if we wanted to put a few cattle, we could. We have a well that supports that. My feeling is that when he bought it, he knew he bought something that was half-acre property. And to crowd, I don't know if any of you have been seeing the property, I recommend you drive out and take a look. It's a long, narrow stretch, and it's very steep. And so the letter says that the city would not be maintaining a road which would be right exactly next to the fence that we have that goes all along the property, which is our property line. And don't know if they plan to scoop up the snow on the bottom and haul it out, but other than that, it would go on our fence and in the canal below, which is not legal. You can't push snow into a canal. So anyway, we welcome him as a neighbor, but we would prefer not to have it rezoned, just leave it as it is. All of the homes on that side of the road are half-acre. And so we prefer not to take that little chunk out and make it into something different. Sid wants to talk to you about the drainage. We've always had a drainage problem, worse now with the subdivisions across the street. The road was raised, I think 3 times, but I know for sure 2. So we just keep getting lower, and the road keeps getting higher. And so we have a drainage problem. And that water, we've got a kind of a moat in front of our house to get the water running. But if they were to build that up and back that water up on us, we'd be in real trouble. So that's another thing that we would be concerned, who's going to maintain that or fix that so it's not a bigger problem. It didn't get fixed with the subdivision across the street with the driveway right across from us. And so, we do, and they said it's only a 100-year storm, but when we get a storm, we get washed out. So, to block that up any further would become a real problem to us. She's right about the congestion, by the way, so that was good that she shared that. Our neighbors have horses, we have horses. To cram 3 homes in between, horses on each side of them, there's gonna be a lot of complaint about flies, about smells, about, agriculture property is what it was there for, half acre. You wanna say something?
Well, she commented on a little of it was my drainage. The other thing is that all this water that runs off this road down towards the canal, where's it gonna go? You can't put it in the High Line Canal. So that's one of the problems.
And right now, it passes us, but it goes on his property. So somehow it's got to go further down the road, which will run on Steins, and ever since they did the subdivision, they're running 2 sump pumps around, year-round because of the drainage. So there's a big problem there. Anyway, we would prefer not to have it rezoned to smaller acreage.
Thank you.
Thank you.
I'm Jeff Nostrom. I live at 1015 North Valley View Drive, straight across the street from Val Gibbs. I can't say it as eloquently as the letter put it out there, but I agree with it completely. That terrain, how that piece of ground drops off right there, you're gonna have a heck of a intersection trying to get them up out of there onto that. So the least amount of homes in there, the better for traffic congestion.
Thank you. Any other comments? Going once. Jesus, did you want to speak your piece now? Give us your opinion. Come up to the mic if you can, please.
We've worked on this stuff with Steve here, and I've met with the builder, and we took a lot of these things into consideration. Believe me, I wouldn't have proposed this or I wouldn't waste your time if we didn't think it was something that would be feasible. I think even if I would build my own house on there, I guess it would be the same danger with 3 houses or 1 house if it's congested. 1 house versus 3, believe me, I've seen congested stuff. And then the second thing, I think I met this lady before, and when we were out there that one day, Steve, May of last year, I think, and I spoke to my neighbor there. At that time, we had talked about me doing that, and I believe, and maybe I had misunderstood, but I thought you had said that we were okay to dig across your yard because it was pasture, as long as we would put it back how it was. And so with that in mind, that seemed to be one of the bigger issues, was trying to tie into that sewer line. So when the lady here gave me the green light, that's when we had Paul come out to, I don't know his last name, isn't the...
Oldham.
Correct. And so he came out to make sure that it was deep enough, and so we checked that box too for the sewer. So believe me, we thought about all these things. The builder I'm working with, it's not a new builder. He's actually built a lot of stuff here in Tremont, and so rest assured, we did take that into consideration. If I wouldn't want to put my kids in danger. I've seen danger. And if that were an issue, we wouldn't be pushing for this. So I appreciate and I respect your comments and I respect your concerns. So I just leave it up to the panel to decide one way or the other. But I appreciate you guys taking your time for coming out here today too. Thank you.
Thanks. Any further comments? Where did my agenda go? There it is. Hearing none, we'll close the public hearing and move on to number 6, new business, discussion and consideration of proposed zoning map amendment on 1 acre parcel of property located 2495 West 1000 North. The proposed rezone would be from current R120 half acre zoning to R110 quarter acre zoning. Discussion.
So So I do have a couple of questions that was brought up. That drainage, that, I've driven down there in the springtime and you do see water coming down that road. I mean, I know that that's a hot item of topic, talking to the public. What are we doing about that drainage or what? You can see the stream coming down on the south side of the road.
Did he address that in his plan?
That's what I was wondering if the engineers or,
I'm not sure if it's really his job to
Yeah, I
address the
don't- yeah.
neighboring property's water
Point specifically, but
from a site plan perspective, you mean?
usually anything less than an acre or less, usually is just on site. There's no
okay. Whatever.
one could run out on the street like single family homes.
Mhm.
Their driveways right into the gutter of the street. So anything less than an acre.
And some of us, they stay in the gutter.
But yeah,
Works.
Yeah, there's some gutters that aren't appreciated.
Okay, and then my next question I had is the animals. So we're back to kind of the animal rights, doing a multifamily next to a single, or, sorry, the different zone, densities, yes, sorry. But it looks like what they were talking about, I think, is zoned in the city, or the county, right? Am I seeing it right?
R120 has animal rights. The R110 does not.
Okay,
They're
so,
all R120. All the neighbors are R120, which has limited animal rights.
okay, so, but look, I mean, if you look at the map we've been given, isn't that in the
That's
county,
behind
this
it.
bottom part?
Yes, yes.
So I just wonder, I mean, are we gonna get back to, what we've talked about before, where there's not agriculture for say, are they gonna be able to complain about their horses
That's
and
not
their
county.
animals?
County's not till over here.
Oh, there it is, okay. I was trying to figure out how my map matched that map.
Take that, go up just a little bit with that.
Yeah,
right.
See what I'm saying?
Yeah.
I mean, are they gonna be able, these houses be able to, they're gonna be surrounded by,
Well, all of them already
Agriculture.
have animals. They all have, this whole entire street has animal rights.
oh,
on
they,
both
okay,
sides.
on both sides, they
So
do?
this green, the R120 green zone, which is basically almost everywhere around it, is all animal rights,
Okay,
technically. So the animals, I mean, I guess could be an issue for the incoming folks that can't have animals that are next to the folks who can. You
so
know,
the
because
R110 is not,
it does not allow animals, correct?
okay.
At least to
They
my
can't
knowledge, correct?
complain. Okay, but they can't complain about the R120 having animals then?
Well, they can, but.
Yeah, because I
They
thought
have a
we
right
had
to
talked
do it.
about this.
They will,
Okay.
yeah.
Oh, okay. A certain amount per,
Yeah, they have a limited amount, but the neighbors would have a right to have the animals, and of course, they're allowed in the county.
okay.
But it is, I mean, I guess the bigger issue is just kind of the spot zone that it would be. It would be kind of a one little
Across the
It's
canal.
R1.
It's actually contiguous with,
Across the canal.
all be the canals there
Okay.
with the
With that other piece below it.
subdivision to the south, and across the street is R112. It's not,
Okay,
not a bigger, any more of a bigger
true.
zone. The same style of home could be built on them.
I do have a question. When the city does fix that road, hopefully it's soon. And they have to build it up and put curb and gutter in, if they do that, I guess, because they started here by, what's it called? The Freightliner and stuff, working their way up the side of the hill there. That's gonna extend onto the properties that he's talking about. And that's gonna even change the angle of that driveway even higher, correct? It's gonna be even steeper because it's gonna push that out, and then it's gonna be, instead of right here, it's gonna be out to
On-
here.
On his
Yeah.
or the others? Well, we've already got that ordinance in place that he accommodates that with the,
Different setback right there, or,
with the,
It was like, what was it, last year that we did that ordinance that basically widened out the side of the street to allow this to
50
happen?
feet to get the proper slope easement when that road is taken. So his property would be, it's the next properties that exist that's gonna be interesting on how the road gets redone and how
Yeah.
their accesses will accommodate. That particular piece from the entry into Spring Acres
2,500 to 26. I mean, there's 2 or 3 homes right there that are gonna be exciting to work around.
Yeah. That's what I'm wondering, if this is gonna turn into that as well, but you don't think it will?
This one won't. They could build up that first lot a little more, plus have that setback to get a slope that
But, and then if he doesn't have access for right of way for sewer, then it's a no-go anyway.
well, they could pump to the sewer up on 1,000 West, or on 10th North. Sewer runs across 10th North.
Okay.
And really, I guess in theory, if we did the road the way it is and the city puts the curb and gutter in, the road going, straight with that other road would catch the water and run it down rather than run it into the basements of all the neighbors in theory. But
Well, hopefully,
Instead of
when the
collected in the
road,
dirt.
when 1,000 West gets redone here,
This year?
I don't know when that'll be. I think it's on the top of the list, but it's expensive,
right,
that the drainage and all that'll get
addressed.
taken care of.
Yeah, I guess I don't feel like we should punish him for his neighbor's drainage. Because
No.
if you're on a hill, I mean,
For sure.
water's coming down the hill either way.
The road's on the west side of this property. So between the road and the property owners, there's a road coming down. Is there a curb and gutter in there to catch water?
I didn't think so, was there? I didn't.
There's not right now.
Not a requirement for it on a private lane.
Okay.
And there's not a requirement that he asphalt the total width of the private lane.
It's 12 feet, right?
There would be some roughage between that and the property line, if that's what you want to call it.
Burrow pit or something.
Oh, yeah. But you can't guide the water into the canal, right?
Well, not specifically.
Oh,
But that's
okay.
where it's draining now. I'm sure.
Dirt.
Runs downhill until it finds the hole to run away. But yeah, I mean, if you call the canal, they're gonna say.
Can't put a
"No, you
pipe.
can't."
Yeah,
A-
yeah.
A storm drain and a pipe right in the canal.
Even
Yeah.
though that's what the whole city drains into, technically, historically.
Brings into Malad, yeah. That and Salt Creek and.
Yeah. Any further discussion?
So is the sewer the only utility that there's a little bit of an issue with, the rest of them are fine? Is that what the?
I don't think there's issues with the sewer, is it? They've just got to put a lift pump in.
They'd have to, probably couldn't do a
Each
basement.
property have to have a pump?
More than likely, yeah.
It's fairly normal. Most of the subdivisions are full of pumps. Garfield over here, every single one of them has a pump. Because the sewer is fairly shallow in Main Street and everything on the south side pumps up. Every home I've ever had has had a pump.
That's right in your home?
Yeah. It's
Little
just in the
barrel
basement.
in the floor with a grinder pump, your own little system there that liquefies it and sends it out to
Pressurizes it.
city or septic tank or whatever the case may be.
Not a big deal as long as you don't lose power.
Right.
Well, and
For me, it's not because the main level flows, right?
normally it's just the basement plumbing.
Yeah.
A lot of basements remain unfinished for quite a while, and the pump may or may not be used other than condensation from the furnace. If you finish the basement, or you had your laundry room down there and you had a bathroom down there, then it'd get a little more use. It's not, I haven't seen one in my entirety here of a whole house on one. If they put a basement in and the upper level can't gravity feed, then the whole house would be on one, which it would be, that would be where the power would be a,
We've actually put them in, we've got them in multiple commercial applications as well up in Idaho. And they actually make a nicer one that has a double pump with a battery backup built into it. And it's worked fine. So if one pump fails, the other one picks it up and then it has a battery backup built in. So the sewer part of it, I'm not too worried about. Just, I mean, that's kind of the homeowner's deal. I don't, I'm not sure that's really a zoning consideration.
Not, yeah, it isn't the greatest thing for a whole house, you know, certainly a maintenance thing, but
Sure.
your whole house is a maintenance thing.
Yep. And maybe some of, it's possible maybe that the upper house might still flow on the upper level, would it?
It's possible if it builded up and done slab on grade and didn't do a basement, then yeah,
At least the
house.
upstairs would probably flow if they built it up a little.
I don't recall what the depth of that sewer is. Do you remember, Jesse? He's got down his phone.
So I know he mentioned this, but I cannot remember. On the west side, is there a fence? Are you putting a fence?
Sounds like there's an animal fence. One of the neighbors had.
Oh, the
mentioned-
neighbor's fence is already there.
Yeah, kind of
So
a,
you just use the neighbor's fence?
it's just kind of a barbed wire fence, I
Yeah.
think. What is it? Is it chain link? There's no fence?
On the west side?
On the west side there is, between us.
I was thinking it was,
between my property and his.
oh,
On the
yes.
south side, yeah, there's no fence.
On the east side, there's no fence.
My horses are on that property.
Okay.
So, to the east of their property, I'll show you this. that one.
So you're currently using the neighbors on the west proper fence line as your property line,
Corner piece, this
Uh-huh.
high piece is our property.
but you have no fence.
Have no fence there. Our horses are running on that property as well.
Does your property run all the way up to the point there?
Yes.
11 feet deep?
On the one that runs on
That's
the
a,
east side.
that's
of
a,
the property. Not the one, correct, that's the one that's on measure, not.
from that road.
Well, it probably doesn't elevate that much. It's probably still 8 feet.
They can build houses on the side of a mountain anymore.
Yeah. What was it, 8 feet depth, you thought?
Well, if he went straight across in front of his home, it'd probably be around 8 feet. West of, or east of these guys' property, it's at 11 feet.
Okay.
So whoever's good with the 2% math can backtrack that, I don't know, 200 feet or something like that.
But so the sewer doesn't come up all the way to this lot? That's why they've got to run across the front of the other one?
Well, what the sewer did back in the day is it goes down the green line, that
Subdivision line?
the subdivision with the smaller lots and the 2530 west in that range, the green line right there. That's almost where the sewer line runs. It runs behind it might be a little farther west, but yeah, it runs right, that's how it was put in years ago when Spring Acres was developed. So it runs across 10th to catch Spring Acres and continues west till it
So it
isn't
runs through
useful
that corner
anymore.
piece?
Pardon?
It runs through that corner piece?
Yeah, and then it
Okay.
goes through the corner piece somewhere where her arrow is, give or take, somewhere in that area is where it runs south.
But really, I guess in theory, if they're not within 300 feet, do they not have to hook on?
They are within 300 feet, they're within 300 of 10th North.
Okay.
That's
and-
where the pump would.
And do they, I guess they probably really don't need an easement because they can use the road right of way to do it, yeah? Or do they need an easement from the neighbor for the sewer?
To go in the street? No, it'd be like any house.
Well, that's what I was thinking. So they don't really need the easement,
Well, it'd be nicer to gravity flow, but yeah, they could go to
go to the street and,
just makes the house plan a little different, may not be as,
okay.
may not have a basement or whatever.
Entertain a motion. Unless did you have any other comments?
All the other utilities are good. The water state follows that.
So this would be a recommendation to the city council. Either way, it would go to the city council.
And they're affordable homes. Homes?
There's such a thing.
On a 10,000 acre
6,000 square feet.
We haven't quite finalized the subdivision yet. Of course, you've seen a copy of that. You still got to go through that final process. I don't think you've done the preliminary on it. So
Didn't we last time? No?
you just looked at it, and that was to show you, or to
See if it was
Physically.
Heads up.
see it, yeah.
Okay.
pre-public hearing.
So tonight we're rezoning it.
We're just
Recommending.
recommending it back, yeah. So I would entertain a
Either
motion,
yay, or, either a yay or a nay or
Right.
whatever.
or yeah, a table if there's additional information or something we need to collect.
Yeah, if you want to go out and look at the site or whatever to get an idea. We still have one tabled we need to deal with. Keep tabling, you'll have a lot of,
We got a big table.
you got a big table?
What other one's tabled?
The,
Oh, by McKinley?
yeah,
They had a bunch of stuff they had to
Collect.
anyway. It was pretty
It-
good.
it should be coming pretty close.
I'll say it again, I'll entertain a motion.
If it dies lack of motion, it still goes it still goes to city council for them to make a decision.
Well, I guess it's up to you guys if you want to have a motion or not.
And that road's gonna connect, they're gonna meet, right?
Yep. Yeah, on the top.
Move that.
Yeah. The one thing that, according to that lady's letter and that, as it comes up, when it gets close to the road, can it come up more flat so that, instead of they're up on an angle, so, because that could be dangerous if they're coming up like that and they couldn't see as well. But if they were able to get up on, like 20 feet back, if it was level with the road.
There's certain parameters even a driveway
To meet
has to,
that.
and that's something our engineer will, I think we even discussed that on site, that
Yeah, because
Would have to
if it
build
gets
up
them
a
up
little
where they
bit,
can see,
yeah.
then that would litigate some of that safety issue that they're talking about.
Well, in fact, it might be safer than it would be because I think a lot of those homes already have that lip, but the homes really aren't required to build it up as much as
Well,
like this would be.
and 50 years, 40 years ago or whatever, the Gibbs's home was about all that was there. You drove right onto the road. Like I say, over time, we've
Yeah.
improved the road and,
Made it taller.
and I'm not sure if, our engineers are certainly looking at the best way to fix that road, whether it gets raised or whether it can be lowered in certain areas and, dealt with that way. So it's hard to determine at this point. But it will get a wide road and everybody will be happy with a new road one day.
Urban better.
Sidewalk. All the good stuff.
I would entertain a motion. We'll go motionless and recommend it back without a motion, I guess. I guess we don't really recommend it. It just goes anyway.
Well, he does have the application, like you learned. He's certainly vested to have an answer, and the council would be the final answer.
Right. Don't all speak at once, please.
Well, I guess I make a motion to submit it for approval to the city council.
Okay, we have a motion. Do you have a second?
Not unusual to die of lack of second either, so.
No second. Motion dies. Do we have any other motions?
Motion to adjourn.
Well, you're right. You're in a position that you're not gonna make everyone happy.
Make a motion, we table it then,
For what?
and go look at the situation and see where we're at, and
You can do that.
I think that's what we should do. I'll make that motion to table it, go look at the property and kind of see the situation we're in up there.
Okay, we have a motion. Do we have a second?
Yeah, I'll second that.
We have a motion and a second. Any further discussion? All in favor?
Aye.
Aye.
Any opposed? Motion carries.
Next meeting, good, close enough?
Yeah, it's fine.
Okay.
I think that's a good choice.
Let's do it. Thank you. Thanks, everyone, for coming.
All bounces, Jesse.
I'll make a motion that we adjourn.
Motion to adjourn. Do we have a second?
Second that motion.
We have a motion by Lane, second by Jordan.
Aye.
All in favor?
Aye.
Any opposed? Motion carries.
Throw us on that too. I'm better at reading it than I am.
I'll send you guys his presentation too.
Yeah,
Oh, that'd be great. That'd be great.
Now I'm gonna shut all of these meetings.
Thanks, guys.
So what are you thinking on that? I mean, I just.